All right, we're back on the record in the 53rd Circuit Court for the County of Sheboygan. And we're here next for the case of People of the State of Michigan versus Justin Germaine Smith, file 19-5888FC. And we have Mr. Germaine Smith present in the courtroom with us, with his attorney, Mr. Gilbert, and the prosecuting attorney, Ms. Goodrich. And we are providing enhanced public access online in this matter. And Mr. Germaine Smith, my first question to you is, we're here for sentencing on a charge of criminal sexual conduct in the 4th degree. That's a high court misdemeanor punishable by up to 2 years in the state prison. Have you had a chance to review the pre-sentence investigation report and recommendations with your attorney?
He did send me them in an email, and I went over them.
Okay.
But this is the first time we've been face to face.
Okay. So do you need any more time to review them with them, or are you all set to go?
I'm all set.
All right. And Mr. Gilbert, do you have any additions or corrections to the factual information in that report?
I do not, Your Honor. In addition to talking to him today, I did call him via telephone to go over the PSI.
Okay. Ms. Goodrich, any additions or corrections to the report?
No, Your Honor.
The advisory guidelines are scored at 0 to 9 months. Any scoring challenges, Mr. Gilbert?
Yeah, we do, Your Honor. There's only two places in the scoring that my client took points, and that would be on the OV, and that would be OV 11. He was scored 25 points for penetration.
In this Michigan courtroom, every word carries weight, and every mistake has consequences. From sentencing battles to broken probation promises, the judge is watching it all. Today, freedom hangs by a thread.
My client has been adamant, and even in the plea taking, admitted to improper touching of the victim, however, denied any type of penetration. We have asked that the OV 11 be scored as a 0 due to no penetration.
Okay, Ms. Goodrich, response?
Your Honor, based on his plea, he did not admit to the penetration. However, I believe it's in the factual basis. The agent description of the offense.
Can you?
About the penetration, and I believe that's where the scoring would have come. Sorry, I was not made aware that there would be this objection prior to the hearing.
And that's true, I did not.
Well, in my review of the pre-sentence investigation report, there was, you see that there were some information in there to support the penetration. Let me see if I can find that.
You're on page, see it before consecutive sentences, the third paragraph up, the last couple sentences address that issue.
Okay, here we go. All right, so on the last page that has the agent's description of the offense, Mr. Gilbert, and also flows into consecutive sentences. That third paragraph up from the consecutive sentences, the last 3 sentences, 3 or 4 sentences, those are statements reported to Ms. Junker by the victim. Those statements would support a score. So, I mean, you previously indicated you didn't have any additions or corrections to the information of the PSI. Are you challenging that information in the PSI? Do we need to have testimony from Ms. Junker?
Hold on 1 minute, Your Honor.
Okay, I mean, we don't score based only on what the defendant admits. We base on what the factual basis is by a preponderance of the evidence. So if he's challenging that information, we'll have a hearing with, and hearsay is admissible at sentencing proceedings. We'll have Ms. Junker testify that the victim told her that, and that would be scoreable.
Just 1 moment.
Okay.
Your Honor, there is a correction. We're challenging that portion of the PSI and would like the probation officer to testify to how she obtained that information.
Well, the probation officer is going to say she got it from a police report. So we're going to need to have a witness testify. So we're going to have to adjourn the sentencing to accommodate that. So you want us to do that?
Yes, Your Honor.
Okay, what other scoring challenges do you have so we know which witnesses that the prosecutor?
That's it, Your Honor. That's it.
All right, what I'm going to do though, Mr. Germaine Smith has admitted to a sexual offense against a minor. I'm going to pull his bond and remand under the custody of the Chicago County Sheriff right now. And we'll schedule the sentencing at a later date, but you're going to go to jail right now, Mr. Germaine Smith. I'll revoke your bond and we'll get with the prosecutor's office. We'll get with the assignment clerk and schedule a special time where we can have an evidentiary hearing on your scoring challenge. Okay.
Thank you, Your Honor.
Thank you.
I got my medicine in my pocket if you want to know what the bag is.
All right, we're back on the record in the 53rd Circuit Court, and we're calling People v. Paulino, file 21-6122FH. We have Ms. Paulino appearing by Zoom audio only with some video problems. We have her attorney, Mr. Gilbert, in the courtroom, as is the prosecuting attorney, Ms. Goodrich, and we're providing public access online. The time date set for a docket call. Mr. Gilbert, do you know how we'll proceed?
Your Honor, when I spoke with Ms. Paulino, we were going to ask the court to put this on the trial docket. However, I have spoken with the prosecutor again since that conversation, and she's come up with some alternatives of a possible resolution. I believe she wants me to talk with the agency involved in this case directly and see if I can work something out, and I'm more than happy to do that. So we don't have a resolution at this point.
Okay.
But I think there's one on the horizon.
Okay, any objection to a continuance, Ms. Goodrich?
No objection.
We can continue this to August 10th at 2 p.m., but we'll schedule that to be held in person. Okay, Ms. Paulino, did you hear that?
I heard that. The last part I didn't hear.
It'll be
reschedule
here in
when?
the courtroom,
Okay.
August 10th, 2 p.m., here in the courtroom in person.
Okay. So then the court is going to open.
I can't hear you.
The court will be open. So we go right to the court.
Yep.
Okay. Okay.
Okay, see you then.
Okay. Am I done now?
Yep, you're done. Have a
All
good day.
Bye bye. You too. Bye bye.
Let's call People v. Caleb Stewart, two file numbers 21-6067 and 6085FH. It's the time and date set for sentencing. And bless you. And Mr. Stewart has been participating in our recovery court program and is scheduled for sentencing today into the recovery court formally. And sadly, though, he's not here today. Mr. Gilbert, do you have any information about that?
Your Honor, we've been trying to contact him. I saw him as recently as last week in our recovery court, and so I'm not too sure why he's not here today. I did contact one of his contact numbers. They said he was having an issue with his phone, that it broke, and that he had to get insurance for it. She was going to try to relay a message to him by instant messenger. However, he's not here. However, I don't understand any reason other than an oversight that he wouldn't be here, because this is what he's wanted for quite some time. So I'm slightly confused.
All right, well, we are scheduled for a recovery court weekly review hearing tomorrow morning. Ms. Goodrich, any objection to us seeing if he appears tomorrow morning and we can sentence him at the end of that hearing? Or?
No objection.
All right, so I'm going to give him until tomorrow morning. If he's a no-show tomorrow morning, we'll have the warrant.
Understandable.
All right, and then there's a Kiana. Let me see who that is. Kiana's oh, this is Mr. McQuaid. All right.
Can you hear me, Your Honor?
Yes. All right. Are you Mr. McQuaid?
Yes, Your Honor.
All right. So we're calling the case of People versus Cameron McQuaid, file 18-5564FH. Mr. McQuaid is appearing by Zoom video. And this is the probation agent's motion to extend probation. The request is that the probation would be extended by a year to expire instead of on August 21st, 2021, to extend it to August 21st, 2022, because Mr. McQuaid has not addressed financial obligations, completed substance abuse treatment program, GED requirements, and then he did not address them previously because he had been a probation absconder and then had served a jail sentence, and now he's released from jail and back out on probation. So, Mr. Gilbert, are you here on that case?
Your Honor, I don't know necessarily. I did try to get a hold of Mr. McQuaid so I can discuss it with him. However, none of the numbers that I had worked any longer. So I'm here if the court wants me to.
Okay, well, it's unclear from the probation or from the criminal justice reforms whether indigent defense would be provided at a motion to extend probation. We had taken the position that we certainly would if people want that. But Mr. McQuaid, let me just ask you here. So we had some issues on probation, and then you had a violation and had to sit some time. Now you're back on probation. Looks like there's still some things you need to do. Do you have any objection to us extending your probation 1 year to August 2022 to give you time to complete those things and possibly discharge successful?
Your Honor, I was going to ask if there's any way I could possibly get off probation and still address my court fines and stuff like that.
Well, it's not just fines, it's substance abuse treatment, GED. Have you done those things yet?
I actually did 3 out of the 4 GED tests, Your Honor. I'm currently trying to get an appointment set up for the math GED.
All right. Have you successfully completed a course of substance abuse treatment?
I did go to Harbor Hall once, Your Honor. I believe I was supposed to do another one, and I did not make it in there.
All right. Does that sound to you like you're done with probation then?
No, Your Honor.
All right. I'm going to extend your probation to August 21st of 2022, because the other option, Mr. McQuaid, if we don't extend your probation, you haven't successfully complied. So we'd have a violation hearing and decide whether to give you more jail and how much. So it's not like the options are cut you loose or keep you on. The questions are, do we violate you or do we give you more time? So understanding those options, do you have any problem if I give you more time?
I'd just like to continue probation then, Your Honor.
Okay, I think that's a good decision, Mr. McQuaid. So I've signed the order extending your probation to August 21st, 2022. So be in touch with your supervising agent and make sure you get those things done. I don't want to have to give you more jail in this case. I really want you to complete those things so we can discharge you successful, okay?
Yes, Your Honor.
Okay, good luck.
Thank you.
Bring in Mr. Stribick. I honestly have no idea under the criminal justice reforms whether we did that right. I think we did it in a way that makes sense to me.
Hey, I'm in court right now, and
Oh, no. Mr. Stribick, can you hear me?
I can do that. Read my record. Can't get anybody to answer the phone.
Mr. Stribick, can you hear us?
See if I can find right now. I got one. I got a couple of them. They're probably
Hold up. Hold on. All right, can you hear me, Mr. Stribick?
not really. Okay, yeah.
All right, so we're back on the record. We're recalling the cases of People versus Joseph Stribick. It's filed 21-6081 and 6116FH. We've given Mr. Gilbert time to discuss the matter with Mr. Stribick. And we're here on a docket call and bond violation hearing for contempt. And Mr. Stribick, I know it was that Mr. Gilbert advised you here in the court, we have no proof that you have taken a single drug test.
I understand that. I have one of my receipts right here. And I've taken over 5 tests there for sure. I asked them though that he said they keep all their records and that they will fax them to the courts if I need them. But the number I got for the place, I text it and I call it and they won't pick up. Usually not till after 5.
Your Honor, Mr. Stribick has advised me, I believe he's going to the advanced.
We just, hold on. Turn your camera back on, Mr. Stribick. Go ahead, he's there. Sure.
Your Honor, Mr. Stribick advised me that he had been testing an advanced drug testing. I informed him that he needs to get a hold of them and get receipts faxed to the court. So that doesn't seem to be happening.
Mr. Stribick, can you hear me? We seem to have lost him. I'm going to add this to next Tuesday's docket at 3:40 in person. And have a bond violation hearing at the same time. Let's see if this is him so I can tell him that. We'll give him a chance to get those receipts. It's not the court's job to track down those receipts.
I understand. And Mr. Stribick has been advised of that.
Okay, Mr. Stribick, can you hear me?
Yeah.
All right, here's what we're gonna do. It's not my job to get the receipts, it's your job. So I'm gonna continue this hearing 1 week. So July 13th.
Could I have
Next
them
Tuesday.
fax them to you guys?
Hang on, just listen for a second. Next Tuesday, July 13th at 3:40 in the afternoon, you're gonna be in my courtroom personally, Mr. Stribick.
Okay.
And you can get
July
any of those
13th?
receipts to July 13th, 3:40 in the afternoon. And you can provide any of those receipts to your attorney before then. If he wants you to send them to the court, go ahead and do that. But I would check with Mr. Gilbert first.
I'll have them for sure.
And we'll get this sorted out next Tuesday. But next Tuesday, Mr. Stribick, I just want you to know, if I'm not convinced that you are testing as required, I will be revoking your bond that day.
Well, I do mine online, so I have history of how I do it. I go online on the My Call-In, and I do it like that. So I have record of every morning when I do it on the phone.
Okay.
I don't
all right,
call the
well,
number. I do it all online.
Okay, I'm just letting you know, we've got to make sure that you're testing as required, okay? So get that information to Mr. Gilbert.
I'll get everything I can together.
Yes, yeah, we got to have the test results, Mr. Stribick, not just that you were calling in. We don't have any of the test results.
Yeah, I mean, I don't know. It's out of my hands. I was just gonna go to him and tell him I need them because I mean, I just pay him the $20 and he gives me a receipt. I got them.
Well, let me tell you, if the agency that you're going to is not getting receipts to the court, you might want to think about going to somewhere else to get tests. There are 3 agencies in town. If one of them is not helping you out.
Yeah, you're right. Never knew there was
I would switch agencies before I go to jail for somebody.
Yeah, I agree. Yeah, I will. I'll start going to
But
the one in
that's-
town.
That's your job to sort out, not mine. So you've got to prove to us that your testing is required. So we'll see you
Well,
next Tuesday in
I
the
have
court.
been calling it and I have been testing. I just got to get the paperwork from them guys. He says they have it, and if I ever need it, I'll get it.
Okay, all right, we'll see you next Tuesday at 3:40 in the courtroom, Mr. Sturdy.
Okay, thank you.
Okay, all right, and I believe that concludes our docket this afternoon. We'll put over Mr. Stewart until tomorrow morning at the conclusion of recovered court.
Thank you, Your Honor.
All right.
In this courtroom, excuses don't stand, evidence does. Deadlines matter. Accountability matters more. Because when you stand before the bench, your freedom depends on what you can prove.